witness, some kind of witness to the crime, and they testify to the grand jury, but by the time we get to trial, that witness is dead. So the state wants to introduce a transcript of their testimony that they made to the grand jury. Sandra Apodaca, what do you think? Where are you? Over there, okay. Well, testimony, right? Testimony, let's see. No, you can't introduce it. It's definitely hearsay because it's an out-of-court statement being offered for the truth of the matter asserted. But the problem is that if you look at let's see. What am I looking for? Oh, prior statement. Well, yeah. I mean, the distinction is that. Wait, here we go. Declarant witnesses prior statement exception for hearsay. Oh, 804. That's what it is. That's why I was lost. 804B1, former testimony, right? 804, the witness is unavailable because she's dead. So she meets the unavailability requirement, but these are the kind of reliable hearsay exceptions in 804. Former testimony is admissible as an exclusion, as an exception to the hearsay rule, that was given as a witness at a trial, hearing, or lawful deposition, whether given during the current proceeding or a different case, and is now offered against a party who had an opportunity and similar motive to develop it by direct, cross, or redirect examination. The suspect, the target of the grand jury investigation, does not have a right to cross-examine grand jury witnesses. So because there was no opportunity to cross-examine the dead witness, this does not qualify under 804 as prior testimony. Second part of the question, that testimony does. If the dead witness had testified in the preliminary hearing as opposed to the grand jury, preliminary hearing is an adversarial proceeding in which you can and does cross-examine her. So if under 804 the prior testimony of the dead witness can always be used where the party against whom is being introduced had a chance to cross. But if they didn't have a chance to cross, forget about it. All right, 804B2, number 14 scenario is the classic dying declaration. This is another 804 known to the common law for hundreds of years. The witness at trial is the EMT who was treating the victim who eventually died in the ambulance on the way to the hospital. And she subsequently died at the hospital. And he may testify at trial, and they've accused one guy of being the killer. He may testify at trial that before she died, while she was in the ambulance, while they were riding to the hospital, she blurted out that it actually wasn't the defendant that stabbed her, but her brother-in-law. Now, normally, I mean, if it's something the defendant says, it's an admission, it's not hearsay, if it hurts the defendant, but it is hearsay and not admissible, it helps the defendant. But for purposes of dying declaration, whatever it is the victim said, whether it helps the defendant or hurts the defendant, is completely admissible so long as the foundation is laid when the witness, when the EMT is on the stand, he'll be asked questions about what kind of condition she was in. Well, she was in critical condition. I thought she was going to die. Did she manifest by her behavior or anything she said a consciousness that she was in big trouble and might die? Yeah. She was crying and saying, I'm too young to die and I'll miss my babies and so on and so forth. So you lay that kind of foundation for the dying declaration under 804B2. Under 804B2, the EMT can testify in the prosecution for homicide. Now in this case, because of the unusual thing that the dead person said that actually helps the defendant, this is a defense witness. A statement that the declarant, while believing the declarant's death to be imminent, made about the cause or the circumstances under which they came to be dying. 15, the state wants to introduce at defendant's trial a statement made by a co-defendant who has since died that he and the defendant conspired to and did commit the crime together. Well, that might be a co-defendant's statement, which is a kind of form of admission, which is not hearsay under 801D2E. But there's also a Sixth Amendment confrontation issue here, because there's no way that the defendant can cross-examine that. So it may be admissible under the hearsay rules and maybe not admissible under the Sixth Amendment.
Would that just come down to the judge's?
Yeah, the judge's weighing and balancing of those two things. I mean, part of the Sixth Amendment, when I've been teaching this course 20 years, the first 10 years I just talked about what the hearsay rules were. It wasn't until 2004 that with the Crawford case, and then there's been several other Supreme Court cases since, we have to also, when we get to the point where we say, okay, the correct decision under the hearsay rules is we let it in, except now we got to take a step back and look at it in terms of the right to confrontation. Because if this is testimonial evidence, which is, directly related to the guilt of the defendant, then it may be a violation of the
So it
Sixth
would
Amendment.
probably come down to who got the admission from the co-defendant?
Well, and it would come down on the judge making sure that the last question the judge asks themselves is, the rules of evidence are fine. Okay, I can apply the rules of evidence as a judge and I can say, okay, this meets one of the exceptions, but my last duty is to apply the Constitution. And it wouldn't be fair because he has no opportunity to cross-examine the out-of-court declarant. 16, Kathy and Joe are out for the Sunday drive and this guy passes them and then she says something to him, look at that maniac, he must be high on something, and then he's on trial for vehicular homicide because he caused a crash like 15 minutes later. For whatever reason, Kathy's not available to testify, but her statement can come in through the testimony of Joe, notwithstanding the hearsay objection, because under 803.1, this is a present sense impression. This is like the diary that the murdered girl kept. This is Kathy saying, describing, or explaining an event. Remember I told you last week, 803.1 present sense impression, it's like Vin Scully calling a Dodger baseball game. He's describing what's going on right now. And that is an exception to the hearsay. And then finally, problem 17 is actually just a variant of problem 5. So, I had to do the exercise to realize how devilishly complicated this stuff is going to be. But I'm not going to be unfair on the test. The only examples that are going to be included on the test are going to be these examples. So,